All right, so welcome tonight to the webinar on superannuation and your will. Um, I specifically wanted to cover this because a lot of people don't realise that their will doesn't cover their superannuation unless you specifically make it. So to make sure superannuation goes to the person that you want it to go to, there's actually a little bit that you need to do to make sure that happens. And even in doing that, a lot of people get it wrong as well. So I'm going to go through tonight what you have to do to make sure that your will goes to the people you want it to go to. And I'm also going to go over who can even get your superannuation directly. And before I jump into all that, I should just introduce myself a little bit better. So my name's Jackie Broman. I know a couple of you know me already. I'm the owner of TBA Law. I'm an accredited wills and estate specialist. So that's what gives me that fancy swirly logo down the bottom. So there's only 80 accredited specialists in wills and estates in Victoria. And it takes an extra level of study to be able to get that. So I went on and did my master's degree specifically in wills and estates, and then did an extra year on top of that with the Law Institute with their examination process to get that accreditation. So that's all the hurdles that you have to jump. But I also have a life. And you can see down the other bottom corner there that some of my greatest loves are my dogs, and also getting out into the ocean and going fishing. So there's just a little reminder in that photo there, and the dog is tied up because he is obsessed with the white water and would jump over to bite the waves if he could. So yeah, it's not a great combination sometimes. Now, in terms of what I do with wills and estates, I do a whole lot of estate planning, obviously. I do a fair bit of succession planning for small businesses as well. And I also do probate and then the administration of an estate after someone passes away. And look, estate planning has changed a lot over the last 50 years or so. A lot of people think that it's still just a will, and they think that their will is a simple will, and then they launch into the structure of their family and what they own, and it's not simple at all. So estate planning in 2020, it should say, is no longer just a will. We look at property ownership. 50 years ago, people didn't own as much property as they do now. They owned it differently. Life was far more simple. So was tax far more simple. 50 years ago, very few people had superannuation. There certainly wasn't compulsory super. So that's added an extra element. People are living far longer. So we've got the longevity of people's lives. They work for 40 years of their life, and then potentially are retired for another 20 to 30 years. And with the longevity comes a decline in capabilities, frailty, and mental illnesses, dementias, declines mentally. And so there's capacity issues. And that has to come into estate planning, and that's why we talk about powers of attorney. So particularly enduring powers of attorney, they endure past you losing capacity, and that's why they're important. Advanced healthcare directives are becoming more and more important, particularly because people want to make sure their wishes are followed. More and more people have trusts, as investment trusts, but also trusts in wills, particularly for protecting of assets, but also for beneficiaries that might be disabled or vulnerable in other ways. Guardianship, now we've always been able to appoint guardians for minor children through your will. That hasn't changed. Who you might appoint may be more of a complex decision now, and under what circumstances and what instructions you leave for them for a minor child. And then aged care is also a big factor as well in affording aged care, and still, you know, a lot of elderly people are still worried about leaving something for their children and not just thinking about their own care. So I think that will be something that slowly changes a bit more over time as well. But yeah, lots of elements in estate planning, superannuation being what we're talking about tonight, because we want to make sure that your superannuation actually gets to where you want it to go. And like I said, your will generally does not cover your superannuation. The reason for that is because superannuation is not an estate asset. So there are only certain assets that automatically fall into your estate. Superannuation is not one of those. It is, in fact, not an asset that you really own until you are old enough to take it out as a lump sum, and then it's no longer superannuation. Then it's just a lump sum that you have that you can invest however you like. While it is in its compulsory phase and you're not old enough to retire and take it, it is held on trust for you by the trustee of the super fund. So you need to tell the trustee of the super fund what you want done with it. And that's what we're going to talk through tonight to make sure that you get that right. Before I go too far into it though, there's a few different types of super funds, and I tend to break them into 3 categories in terms of doing these binding nominations. Industry funds, they are the funds on all the ads where people do these little hand signals. So superannuation industry funds, you know, they're supposed to be lower fees. They're supposed to, you know, look after your members. You've got your standard, your CBUS, your Australian Super, your MTAA, Host Plus, all these sort of ones are industry funds. I'm in an industry fund myself. My super is Legal Super. It, you know, performs fairly well. It has great life insurance and TPD insurance in it. And that's the other thing as well about super funds, is what is covered in your death benefit, which I'll get to shortly as well. So those are your industry funds. Retail funds are sort of middle of the range, not talking about performance necessarily, just talking about complexity more than anything else. So retail funds are the ones that are, you know, AMP or bank ones, MLC, or the funds that can only be accessed by financial planners. I would call those retail funds. And then you've got your self-managed superannuation funds. Now, the difference with these are basically how you can do your nominations as to who you want your funds, your super funds to go to, should you pass away. So industry funds, they all have the form that you need to make a nomination on their website, which you can download as a PDF. Pretty easy. Problem is you need 2 witnesses for it to be valid, just like a will, and they expire every 3 years. So the industry fund ones will automatically expire every 3 years. You need to remember to do them. If you don't redo it, it becomes what is called a non-binding nomination, and then the super fund can decide what they want to do with your money. So the other thing about an industry fund nomination form is that they only allow 1 level nomination. So if something happens to the person that you nominate, you then don't have a nomination at all. Retail funds have a little bit more flexibility about them with their binding nominations. Again, they all have their own form. Quite a few of them allow you to do a non-lapsing binding nomination, so it won't lapse every 3 years. So that is the good thing about retail funds in terms of your succession planning. However, they usually don't allow a second level nomination. So they only allow what happens in the first instance, but if that person has already passed away or passes away with you in the same accident, for example, you still have no nomination. Self-managed funds have much more flexibility because you manage it yourself. You can pretty much use whatever form you like, and hence we have our own brilliant form for anyone with a self-managed super fund, and we can make it non-lapsing, no worries. We can also have second and third level nominations so that it's absolutely certain to know where the super goes. So those are your types of super. So just bear in mind, if you're in industry fund, you obviously have to find the form online, and it will expire every 3 years, so you need to remember to do that. So the form I'm talking about. So I'm talking about binding nominations. So you are essentially, like I said earlier, telling your super fund trustee who you want your superannuation paid to. So you're nominating a beneficiary of your superannuation, telling the super fund directly. So you can do a non-binding nomination. I don't know why you would. Otherwise, it's a binding nomination. Now, what gets paid to your beneficiaries? So the death benefit gets paid. What makes up the death benefit? Whatever you have saved in your super fund, plus any insurance that you have. So those two things are not paid out separately. They are combined as one lump sum and paid to whom you want it paid to. Now, what else about binding nominations? So you can nominate percentages, so you can split it up. It doesn't all have to go to one person. And if you don't have a binding nomination, so your nomination has either lapsed or you haven't done one, what the super fund will do if you pass away is call for applications. So essentially they'll send out applications to anyone that they know is in your immediate family, and they will ask them to make an application, and then they will decide who they want to pay it to and in what percentage. Even if your children are under 18, they may make payments to your children. What they will do is require it to be held in trust until they're 18, and then at 18 the children would get a lump sum, which is why we particularly want to make sure that often that doesn't happen. If funds are going to children, we want to make sure it's in a trust for much longer than 18. So, next slide. All right. So who can get your superannuation? So when you do a binding nomination, like I said earlier, you can nominate who you want. So you name the person and you can name the percentage that they're going to get. So it could be your spouse, 100%. It could be split between your kids if you have two, 50-50. So you can name the people. However, there's only certain categories of people that you're even allowed to name. These people are called superannuation dependents, even if they're dependent on you or not. And they include spouse, children, stepchildren, or financially dependent people. So those 4 categories are the only categories that you can leave your superannuation to directly. This is why I also say that young people need to do wills. One of the main reasons, if a young person has started working, you know, they might have worked for a couple of years before they were 18. Once they get to 18, they should do a will. If they have an industry fund, which is probably what they were signed up for, they will have life insurance on it. In an industry fund, it is usually $200,000 at least to begin with. And so even though your child may think that they don't have anything, there is a big lump sum there. They cannot nominate their parents. They cannot nominate their siblings. None of those categories are in those 4 categories of superannuation dependent that I just listed. So those categories again are a spouse, children, stepchildren, or someone who's financially dependent on you. So young people don't have any of those categories. So what happens to the super? Well, at this point, it can be paid into the estate. And that's generally what the super fund would decide to do. However, we can direct that. So instead of naming someone personally, we can direct that the super get paid into the estate, and then the will can actually deal with it that way. There's a lot of benefits for that. Again, it depends on personal situations, but using super can be a really handy way of doing some fancy estate planning, because particularly in blended families, if you pay super directly to your new spouse, for example, the kids can't challenge that. So if it avoids the estate, it's guaranteed to be fine. Or if your whole estate goes to a new spouse, but you want to give something to your kids from your first marriage, you can do that direct from your super as well. And so they at least get something and everyone's interests are sort of balanced. So that's how we can use the binding nominations when we're doing the estate planning process to try and balance some interests out. Now, the other thing to consider when thinking about who to pay the superannuation to is tax as well. So a spouse doesn't get taxed on superannuation. So trying to pay it to a spouse is probably the best option if you can, if you're worried about the tax. So the super will withhold some tax when they pay the lump sum, but sometimes they don't do it all. And so if your super is paid direct to your kids, for example, the kids would have to declare that and pay some of the super they get as tax. Now, remember, you pay about 14% on the taxable component going into your super. And so the kids only have to make up the difference. They don't have to pay the full amount because there's already been some paid. So there's some considerations there about tax. The other thing is that you don't have to pay a lump sum. You can sort of gift your super to your spouse as a pension if you're already in the pension phase. So this only really relates to people who are old enough to start taking a pension on their super. And once the super turns into a pension, so to speak, you can gift your pension to a spouse. You can't, though, gift your pension to your children. It has to come out as a lump sum for any other party. There are a couple of exceptions to that, but that's the general rule. So tax-free to spouses, you can leave a pension to spouses, otherwise it comes out as a lump sum to anyone else and there's tax to pay. So that is another reason potentially why you do want to leave it into your estate, because then the estate pays the tax and then it evens out what everyone gets through the estate. If super is paid direct to children, they could pay a different rate of tax depending on their income. And so they don't end up in the same, they don't end up with the same amount in their hands. And so if you want your kids to get an equal share, it's unlikely to happen if the super is paid directly to your kids. All right, so I hope that wasn't too overwhelming. That's a whole lot of information just sort of bombarded at you about superannuation without too much context. So it's hard when I'm not talking directly about your situation and your superannuation. So just a quick review before I have a look at some questions. If you do have a question, there's a Q&A tab, or there is a chat tab, so you can pop either of those open and type in a question. Or alternatively, if you're watching a replay, there is a link there that you can send a question via email and I'll answer within 24 hours. So again, the types of super fund that you have depends on the sort of nomination that you can do. The binding nomination is preferable, and the way you do it is via a written form, 2 witnesses, has to be submitted to your super fund that way for it to be valid. And then remember, it's only valid if you nominate the correct categories of people, or if you decide that you do want to pay it into your estate and you direct the super fund to actually pay it there rather than just leave the super fund to decide for themselves. So those are really the main points about making sure your super gets to the people that you want it to go to. So in the chat. All right. Q&A. No open questions there. All right. So I quite often get asked, should I pay my super into my estate? Or should I pay it directly? And it's a tricky question without sitting down with someone and working through your scenario, working out who's in your family and what you want done with your will at the same time. So like I was talking about before, the superannuation can really be used as a handy tool in estate planning, particularly if you think that there is going to be a claim on your estate. So we can do a fair few tricky little things if estate planning is done early enough to make sure that no one challenges your will. So if your superannuation isn't paid into your will, then obviously your superannuation is protected from a challenge. So superannuation can be paid direct to avoid someone who might challenge, and then you can organise some of your other assets as well to make sure that they are also not covered by your will, so they're safe from a challenge too. So those are, that might be a reason why you don't want your super paid into your estate. Another reason might be is that it can take a little bit longer. If you pay the superannuation direct, it can happen quite quickly. If you don't have a binding nomination and the binding nomination has expired and so it's just a non-binding or lapsed nomination, it can take months and months and months to get the superannuation paid. You know, I've had people waiting for 12 months for superannuation because there's no compulsion for the super fund to actually make a decision in a hurry. There is a financial ombudsman that you can complain to about, but essentially, without a binding nomination, they can take the time they need to make their decision. So if you've got people who need to pay a mortgage if you pass away, then potentially paying the superannuation directly will make that faster. If you pay your superannuation into your estate, it will help equalise tax. It will also make sure that your superannuation forms part of any trust that you set up for your children as well. So that is one of the main reasons that I recommend families with young children make sure that their super is directed towards their estate for that period of time. Because if they're setting trusts up for their kids and funds are held in trust until the kids are 25, we want to make sure the super forms part of that and it's all held together so it's maximised, rather than having an issue where their inheritance is held until they're 25, but the superannuation is paid direct to them at 18. And we all can cringe at what an 18-year-old might do with a couple of $100,000. They may not have any of it left by the time they're 25 and they get the rest of their inheritance. But then again, some parents just think, well, you know, I'm gone and that's their life. I hope my internet's okay. I just had a warning that it's a bit unstable. So we'll push on. Question: what wording should be used when nominating your estate as the recipient? So again, this depends on the form from your super fund. So some of the super funds, on their forms, they will have a kind of a grid. And on that grid, you have your line items where you can put people's names. So you put the person's name, their relationship to you, and the percentage that you'd want them to get. Sometimes they want a date of birth as well. And then quite often at the bottom of that grid is a single line item down the bottom which says pay it to my estate and a percentage. So you'd put in 100% if you wanted 100% to your estate, and then you don't have to fill in any other part of the grid, just 100% tick into the estate. So that's what a lot of the forms have. But a lot of the forms also miss out that line item altogether, so they just have the grid. And so in that case, what you would do is you would put the name of your executor, and the relationship to you is not son, daughter, or spouse, because you're not paying it to them in that capacity. You're paying it to them as your legal personal representative. So the person's name and then the relationship would be legal personal representative. And then that would be paid into the estate rather than directly to the person. So that's the wording that you would use. All right, great question. So I'm going to push on, and I'll come back to questions at the very end as well, okay? I just can't see them popping up unless I actually keep clicking around. So coming back again to what is involved in estate planning, and this is the family legacy plan that my firm does and make sure that people cover off on everything, because it's not like just going to a solicitor and saying, I need a will. We actually make sure that everything is looked at. Even if someone comes in and says, I just want a will, we ask about the super and we make sure that that is done because it's one of your biggest assets most of the time. So this little poker chip image here has all the aspects of the family legacy plan that we do at TBA Law. So we look at what property you own and how you own it, because that's really important to work out whether it's an estate asset or a non-estate asset, to work out whether your will covers it or not, or whether there's something else we need to do to make sure that is covered and gets to the person you want it to. Wills are obviously included, enduring powers of attorney. We do your medical treatment decision maker appointments. So that's your medical power of attorney. We do your advanced healthcare directives. So that's what you want with your medical care. If you can't make decisions for yourself, you can leave some instructions and then your medical power of attorney follows those instructions. Your superannuation binding nominations. So if you're doing your family legacy plan with us, we actually print those out and we have those and we sign those at the same time as signing the will, and then we send them back into your super fund for you. We talk about testamentary trusts. So there's a large range of testamentary trusts. The one I was talking about earlier is a minors trust, where you're leaving funds to a child who's under 18. It's a minors trust. So we look at what trusts might be relevant for you and make sure that they work the way you want them to work. Again, if parents are setting up a minors trust for a child, should something happen to them, they want to make sure that the funds can be used for the education of the child until they're an adult. So we make sure that there's the flexibility and the powers in there for that to be able to happen. We have a look at your life insurance as well, not so much TPD, but life insurance too can be similar to super in a way, because you can put a nomination directly on quite a lot of policies. So we just talk through whether it's relevant to have a direct nomination on your life insurance to someone, or whether it's preferable to come into the estate. So we just have a look at that, and particularly the levels of debt and where that life insurance should end up. Instructions to guardians, again, for parents with minor children, we make sure that there's actually some detailed instructions left, because you often don't think through, well, will my guardians understand how I want them to be raised in terms of pocket money, in terms of what extracurricular activities are important to me, in terms of you know, the CFA or some kind of volunteer organisation might be really important to you. So you want them to have that value and have that experience. Family trust appointments. So if someone does have an existing family trust, we need to read the trust deed. We need to make sure that the control of the family trust passes to the right person, because that's not automatic either. It doesn't necessarily go through your will to your executors. A personal effects list. So we try and encourage people not to have a list of all the bits and pieces that they want to give to everyone in a will. You know, if it's this piece of artwork, this vase, this dinner set, all that sort of stuff, we try and get them to list those things separately, because that personal list might change more often than you will. I really don't like having to redo wills just to change a little item like that. It just doesn't seem fair to charge for that. So that's why I put them in a separate list. And then memorial instructions. So the particularly important thing that's relevant in your will is whether you want to be cremated or not. So that goes in there, and it's actually illegal. It's a finable offence for someone to do the opposite to what you say after you pass away. So what does all this involve? So it's essentially 2 appointments. We do them about 2 weeks apart. We send out initial information when someone approaches us, so that they can prepare a bit of information. We have our first appointment. These days we're doing those on Zoom. And it's funny because I've missed the T in appointment in this image, so I better get that fixed. So we do the first appointment via Zoom generally, or phone. In between, so the 2 weeks in between, we then draft all the documents, email them through for review. If there's any information you didn't have at the first appointment, we get that via email in the meantime. So quite often there might be super fund trust deeds, there might be family trust deeds, there might be names and addresses of people that you didn't have the full details of, all that sort of stuff. So all that's done in that 2 weeks, and we go backwards and forwards to have a final set of documents that you're happy with. And then for the second appointment, we sign everything, and it's pretty much all done then. We can now do signing appointments online as well. Under the COVID measures, we can do via audio visual link, the witnessing of documents. And then we deliver it all to you at the very end. So the thing at the second appointment, generally everything is validly signed and finished. But what we generally also have to do after that is get some acceptance pages and things signed by the people that you appoint as power of attorney. So we do that. And then we deliver it all to you with certified copies, electronic copies, and the originals are then held in our safe custody room for safekeeping. So that's the process. It is very quick relatively once you get started, so that it's over and done with and you can tick it off your list of things to do. And then what does it all cost? What does it involve? So for a couple, we charge $1,100 for all of that. For a single person, it's $750, and that includes a guarantee of 12 months after doing your documents. If you need some small changes, that's fine. You can get as many copies of the documents as you like. You can have us to send them to multiple people. You can take your originals with you too if you want. That's no worries either. We don't have a possession of them. They're your documents. People often ask us, well, who should I give my will to? And I say, well, it's your confidential document. It's completely up to you who you want to see it. I don't think there's any issue in letting an executor know what's in the will. I don't necessarily think that they should have a copy because they're probably just going to disregard it or lose it. It's just something else they have to keep. So I think it's best that you keep a copy of your will in with your documents. And the executor will know where to look, and on the copy of the will, when they find it, it has our details, and so they'll be able to contact us and have the original and know where to find that. So yeah, that's the whole process. So I guess thank you for coming along. I hope that was relevant. I tend to talk quickly when I'm passionate about something, and I just think that particularly with super funds, it's been something that the legal industry has lobbied for a while, is to try and stop those binding nominations from lapsing every 3 years, which is just crazy, but also to try and have a standard form, and a form that is actually can have 2 levels of nominations, potentially 3, rather than just a single level. Which can be very risky. Now, the other thing I'll do is just pop my email address into the chat box so that you can copy and paste that. Should you want to email me direct, if you have a quick question, by all means, I'll try and get back to you within 24 hours of you emailing me. During business hours, I try not to check my emails on the weekends. So yeah, if you do have a specific question or you want help finding your form, that's fine as well. Email me, I'll email you the link to your super fund form if you tell me what fund it is, if you're having trouble finding it. And then, yeah, it doesn't have to be special witnesses, any 2 witnesses. So use the same pen when you witness, and then you have to send the original into the fund. So that's generally it for tonight. So thank you again. I'm going to stop the recording, and then if there is anyone who wants to ask any other question, you can.